Good afternoon, everybody. I hope you're all very well and especially safe. I do apologize for my late recording of this video. I think everybody's been desperately waiting for him the whole afternoon already. I'm really sorry. At this very moment, it's the 14th of July and 10 to 4 in the afternoon. It was a bit of a crazy few days. I do apologize for making you wait for this. But let's do this. Today's session and for the month of July, the training is all about early cancellation in terms of the Consumer Protection Act. I think this is a topic that has been widely discussed over the past, well, already 10 years since the promulgation of the CPA. But the practical application, I think in the beginning, it was just great confusion and like, what do we do now? And a tenant can cancel, and is this fair? And all those sort of conversations. We now, I think we at a point where we want to understand practically, how does it work? What happens? And if a tenant cancels, what is the damages that a landlord can claim? And all these sort of important things that we need to understand. So what I've done, and I saw that this worked very well during last month's session, is a proper case study. And luckily, this time around, I have a proper case from SSLR to use and show you exactly what happened and how it works. So let's get straight into it. Once again, I'll touch on the theory, and then from there, we will go into the case study. So, first off, we need to understand the application of the CPA. Now, I think I've bored you with this so many times over. If you are still unclear about when the CPA applies to a lease agreement, please go back to our previous sessions where I dealt with application of the CPA in a lot of detail. And if you are still uncomfortable with that, there is a flow chart on SSLR's website clearly indicating the, I'm so sorry, there's a cat that is also wanting some attention here. So on our website, there is a flow chart clearly indicating the application of Section 14 of the CPA. Once you are comfortable with that, and you know Section 14 of the CPA applies to your lease agreement, you can comfortably apply this. Then we go to theory again. And if we look at Section 14.2 of the CPA, it once again says, despite any provision of the consumer agreement, what does this mean? It means if the agreement says, Mr. Tenant, you're not allowed to cancel the agreement midterm, we don't care that the lease agreement says that. This provision of law will override any such provision in a lease agreement. So despite the provision of the agreement, first off, the consumer may cancel the agreement on the expiry date, that is Section 14.2b1. Section 14.2b2, which I haven't included here, is the portion about cancellation by the landlord if the tenant was in breach. It is a very weird place to slot him in, but that's what's missing here. But then we go to when can a consumer cancel the agreement? A, when the fixed term agreement expires, we know this. Or B, or BB, at any time by giving the supplier 20 business days notice in writing, wait for this, or any other recorded manner or form. The thing is, in terms of your lease agreement, you must agree to the form or manner in which you may communicate. And that is why we have that, because otherwise the tenant can say, I've done it in a recorded form and manner. I wrote it in the sand, you know, while I was busy renovating your property, and I wrote you a message in the sand. That's not a proper recorded manner. And that's why you need to look at the provisions of your lease agreement, see how the parties must communicate. And if the tenant gives you notice in terms of this section, make sure the tenant does it in a proper form, recorded form that is agreed to in terms of the lease agreement. But now, what now? The supplier, being the landlord, what can he do? We say he may impose a reasonable cancellation penalty with respect to any goods, supplies, services delivered, or discounts granted to the consumer in contemplation of the agreement enduring for that specific period. What does this mean? I have seen this in lease agreements, especially multi-lets, where the landlord says the rental is typically, let's call it 3,000 Rand a month for the room. But if you sign a 5-year lease agreement, we can fix that rent at 2,800 Rand per month for the full period, or something like that. If that was the case, but the rent was reduced because of the term of the lease agreement, the landlord is also entitled to claim that portion back. So the reduced rental that the tenant is now paying because of a fixed term agreement. The truth is, guys, you're not going to see this often. It's not a regular occurrence when it comes to normal residential type lease agreements, but it could happen, and be aware of that. But the tenant is also liable to pay the consumer, the supplier, everything that was due in terms of that agreement up to that point. So say, for instance, you have a rear rental and now the tenant cancels. What now? Do you claim the arrear rental as well as the penalty, or what do we do? You can claim both, and luckily our case study deals with both those situations. And also credit the consumer for the amount that remains the property of the consumer. Remember, this is in the context of, let's say, a cell phone contract or another type agreement where you pay in advance, or in the context of a rental where you pay in advance. So the tenant that pays 6 months in advance cancels in month 4, but the landlord can place a new tenant already the day after the tenant leaves the property, the previous tenant. You must refund him the payments that was made in advance. So that is the theory. Important to mention, if your lease agreement is silent on this, you can claim on behalf of the landlord the full damages suffered. What does this mean? Say we have a 12-month contract. Tenant cancels in month 6. Landlord can't place a new tenant for 4 months. The landlord is entitled to that full 4 months rental, but to go to court to claim something like that isn't going to be that easy. The reason is you have to prove your damages. So you have to prove that the rent that the landlord lost is actually a reasonable amount of rent. Then you need to prove that the landlord mitigated his damages. What does this mean? A landlord has an obligation to, in a situation like this, market the property as quickly as possible and to allow the landlord to place a new tenant as quickly as possible, meaning the exiting tenant's damages claim is going to be reduced. Because remember, the landlord can only claim damages to the point where he can place a new tenant and the problem is solved. So he has an obligation to do this. Very important. In our current situation, where, let's take Cape Town for as an example. If the rent was very high and over the past year or so, the rent corrected and it is now less, but the landlord is still adamant that he is going to claim his previous rent, that could be a problem on mitigation of damages, for the simple reason that we do expect the landlord to do everything in his power to place a tenant and mitigate his risk. Yes, if he places a tenant in for a reduced amount of rent, the difference between the exiting tenant's rent and the new incoming tenant's rent will definitely be part of the damages claim for the landlord. Also, the commission. The commission that he paid, procurement commission is calculated, obviously, over the time period of the lease agreement, a percentage on the time period that a lease agreement would run. If the tenant now cancels that agreement midterm and you've paid X amount of money for placement of that tenant and the tenant leaves, the prorated portion that the tenant wasn't there, the landlord can definitely claim from the tenant. Very important. That damages claim is not suffered, but that damages is not suffered by the agent, but by the landlord. So very important to be aware that the agent doesn't have any claim when it comes to this. Only thing a tenant can be liable to pay towards the agent in a situation of early cancellation would be the portion of money that the parties agree to pay should there be an early cancellation. And agencies refer to this in different ways. Some agencies would call this a cancellation fee. Some people will call it a cancellation admin fee. Whatever the case might be, it is important to be aware of the fact that that would be the only thing payable to the agent. The rest of the claim is suffered by the landlord, because remember, the commission was already paid by the landlord at the time of inception of the agreement. So that's suffered by the landlord and not the agent. So the theory behind all of this, I think, is quite important, but actually quite easy. I think you guys have seen this over and over and over and over again. Important. The cancellation notice is given at the time the tenant gives the notice. The tenant sends an email, "Hi agent, I am cancelling the agreement. I will be out on, let's say, the 31st of October. The cancellation is not effective on the moment where the tenant sends that letter. The cancellation is only effective on the last day. So let's take our the case study we're going to be using now. If a tenant sends a notice on the 1st of October, yes, there's a month's notice period, but the Act requires 20 days notice. That notice period can be longer. If it's more than 20 business days, the landlord can mitigate his damages better because he can start marketing earlier. But it doesn't take the penalty away. It doesn't, the notice period, say a tenant gives a 2-month notice period, and that notice period isn't part of the way to, isn't part of the damages that they are paying. That is just the notice period. The damages is only effective on the last day of that lease agreement. So the day that the notice period runs out, that's your cancellation date. Good. So let's get into this case study. Here's the facts. I've done the funniest little screen grabs for you from the lease agreement. I'll show you now on the next page. Please don't judge me. As we all know, we're currently working from home in the weirdest situations. So my IT skills is a little limited, and I had, you know, a bit of limited time. So don't judge me for the next slide, but at least this one is still cute. Okay, so here's the facts of our case. We have a lease agreement that commenced on the 1st of August, 2019. Initial period was 2 years. Original agreed to termination date was the 31st of July, 2021. This is, well, currently 2 weeks from now. And the rent of this property was 20,000 Rand a month. The tenant fell in arrears already shortly after the first lockdown of last year. So say April, May, the tenant was still okay, and then June they started missing payments, things started going bad. On the 10th of August, they were already in arrears in an amount of 58,000 odd Rand, and they have sent a TPN letter of demand. Nothing happened. Tenant didn't pay. Well, I think the tenant paid a little bit, but not the full amount, didn't remedy in full. The landlord didn't want to cancel at the time because the tenant was clearly trying to make payment, and the landlord felt bad about it. But suddenly, and out of the blue, on the 1st of October, the tenant gave notice to the landlord of cancellation to be effective on the 31st of October, 2020. So the poor landlord was like, huh, what is happening here? Instructed us on the 8th of October 2020. And the main reason for the instruction to us was, I don't know what to do. The tenant owes me money. Now they do this cancellation notice. What can I claim? What should I claim? Please help. What now? So then we have done a letter of demand and a further letter, which I'll show you just now. And we also claimed the early cancellation penalty. But what's important to know is, at this moment, the reason why the tenant did the cancellation notice, and I'll show you an extraction from the letter just now, was because the tenant said, you know what, you sent a letter of demand. I couldn't pay that. I still can't pay. I have no idea how I'm going to pay that. So I'm canceling because I couldn't pay. I couldn't pay because of lockdown. So you can't really hold me liable for the reasonable cancellation penalty, can you? Well, unfortunately for the tenant, we can. There is no reason not to pay your rent. And there's no reason not to pay the cancellation penalty. Why? We're not being nasty. If we think that's being nasty, isn't it nasty to just assume, because the landlord is the person owning the property, that he has deeper pockets and that he doesn't have to really claim his damages? He must just suffer his damages and smile politely because shame, the tenant can't afford to pay his rent. This is a very real situation that we are currently faced with. And I think it's a very good case study because we can clearly see the cases from both sides, from both the landlord and the tenant. I'm so sorry, guys. It's amazing what's going on here behind me today. But it's very important to always, if you are the agent, yes, you are acting on behalf of the landlord, but it's very important to keep in mind that it's okay to see both sides of the coin. You just need to make sure that you keep on acting on behalf of the right person. In this particular case, this is the fact. So these are the actual screen grabs that I'm judging myself for. But I just wanted you to show, obviously you can see which lease agreement it's from. I don't think there was an agency involved in this. Well, I actually think there was. It's all coming back to me. There was an agent involved in this matter, but you can see it's based on the TPN leaseback lease. So most of you are using this exact same lease agreement. There's the time period, a 2-year lease agreement. And then the maximum cancellation penalty is a minimum, no less than 1 month and no more than 2 months. I'm sorry, I tried to get the sales commission out, but I couldn't. I have limited graphic skills. So this is the important part. Minimum 1 month, maximum 2 months. And this is the standard clause 21, saying that if a tenant cancels the agreement, he will be liable for the amount agreed to in terms of item 129 of the lease agreement. So the reason why I'm showing this is you will see throughout the litigation now, the only thing that's relevant is the content of the lease agreement. And this is very important to know. So this is the notice the tenant gave on the 1st of October. I have sent you all a copy of the slideshow, so you do have time to carefully read through it and go back to this at a later stage and really get an understanding of what's happening. But the long and the short of what's happening here is, on the 1st of October, the tenant did a letter to the agent to say, Mr. Landlord, I'm so sorry. I do not have the money to pay this rent. I'm really sorry. My income dropped. It was because of lockdown. This is an absolute gemors. I want to get out of this. And the tenant's even really being nice about it, leaving a stable keeper behind to maintain the property at no cost. It is really a very sad letter to read. It's a very sad situation to know that this is the position. I must say, this is the kind of cases that you might sit in and you feel so sorry for the tenant that you forget to just apply the law. Remember, applying the law doesn't mean you created the law. You're just applying what we have and what we are rightly allowed to, apply. It's so important. So unfortunately, this tenant says, I can't pay anymore. It's really stressful. We don't have the money. And then, yeah, at the end, you can see they start sort of raising a few issues. So they are saying things like, oh, we already saw that there was an increase in the COJ account, so in the utility account. And then, so they sort of start playing a bit of they start opening the conversation around, we're not completely, we shouldn't really pay the full damages because there were circumstances that brought us here. Unfortunately, this is not sufficient, and you are still liable for payment of the cancellation penalty. Then, look at me bragging, I will definitely be in trouble, but luckily I think most of our attorneys don't ever see my videos, so please don't tell them. But Khomotso is one of our attorneys, brilliant young attorney, and she was the attorney handling this matter. She did this letter. And so she did this letter on the 9th of October, basically saying, we see that you've done an early cancellation, and she uses the term premature cancellation. You will see in the summons as well. This is the terminology of a litigant. So it's the exact same thing. It's early cancellation, premature cancellation. And she demands that our client is accordingly entitled to recover the reasonable cancellation penalty that you've agreed to in terms of item 1.29. This is the 2 months rent, the maximum 2 months rent being then 40,000 Rand a month. But now look at this. Clearly what's happened from the notice that the tenant gave to where we are now, so in 9 days, suddenly a tenant's refusing access. I remember this case, and the tenant specifically used COVID as an excuse and said, I don't want people in the property because we are worried about contracting COVID. Clearly, as you can see, we've demanded to grant them to grant access. They haven't, unfortunately, and it was a very sad situation, because if they did, we might have been able to mitigate damages. And instead of 40,000 Rand for cancellation penalty, we might have placed the tenant a month later, and that number would have come down by half to 20,000 Rand a month. So this demand was done. You can see from the content of the demand, there's no doubt in our communication that this maximum cancellation penalty in terms of the lease agreement is in fact enforceable. So then they didn't pay. By the 15th of October, we issued summons. And this is just an extract from the particulars of claim. So the particulars of claim is the document attached to the summons setting out your full claim. So I've just gave you paragraphs 13 to 18. And the important thing, the reason why I've done paragraphs 13 through to 15 is that is obviously our claim A. This is the arrear rental claim. The letter of demand was only issued for 58,000 Rand. We did not have to cancel the agreement. We already knew at the time that the tenant will vacate by the 31st of October. So there was no reason for us to act on the cancellation in terms of the letter of demand. We've decided to just stick to the 31st of December. So this is why we haven't done a new letter of demand or anything funny. We haven't cancelled, but we have a higher arrear amount, and this amount is made up from different invoices than what the amount of 58,000 Rand was made up in terms of the letter of the 10th of August. There was no further demand for the 64,000 Rand on arrear rental, but you are able to issue summons on that. This lease agreement does not disallow that, and none of the TPN leases demand before we can issue summons. You need to demand and place somebody on terms before you can cancel, but you don't need to demand before you issue summons. So it's very important to keep this in mind. So we just issued summons for the 64,000 Rand full arrears up to this point of issue of summons. The nice thing here was we knew they were going to vacate on the 31st of October. Luckily, they did. And we can claim a full round October rent in this amount. And that's exactly what Khomoto did here. Then claim B is the early cancellation claim. So regardless of what we see from the Rental Housing Tribunal or from things that you read, this is in an actual court. This was Joburg Magistrates Court, and we simply issue this summons and we claim the following. We tell the court, on or about the first day of October 2019, I am sorry, that was a copy and paste error from my side. It was the 1st of October 2020. A notice to vacate was sent to the plaintiff. So now the plaintiff is obviously the landlord, wherein they informed the plaintiff that they will be vacating the property by the 31st of October 2020. See there, I got my dates right. A copy of the said notice to vacate is attached here to mark as Annexure F. So this is important for you to see in real life. We attach letters, and we must, to court exactly the way they were written. We can't do extractions as I do for you on slideshows. This is what you attach, and please keep that in mind, because whatever we're writing in letters eventually is going to end up in front of a judge or a magistrate. Then we say this was essentially a premature cancellation by the defendant. In light of the defendant's premature cancellation of the lease agreement, the plaintiff is accordingly entitled to recover any damages suffered as a result of the premature cancellation of the lease agreement, by holding the defendants liable for a reasonable cancellation penalty in the amount of 40,000 Rand, which amount is equal to 2 months rental in accordance with clause 1.29 of the lease agreement. This is that item 1.29 that says no less than 1 month, no more than 2 months. So this is the maximum amount, and this is what we bring to court. This is what we've pleaded. Then the next moment, on the 11th on the 10th of February 2020, they file a notice of intention to oppose with our officers, but they don't file a plea. So now I won't bore you with court process, but if you filed your notice of intention to defend, you must file a plea within a certain time period, depending on High Court or Madge Court. And if they don't, we file a notice of bar. A notice of bar says you have 5 court days to file your plea. If you don't, you are now in default. Now, luckily, thanks to the events of the past few weeks in our courts and in our country around default orders and rescissions of judgments and things like that, I think this terminology is starting to be very, household sort of terms. So if you are in default, so you haven't filed your plea, you haven't told the court your side of the story, in action proceedings, we give 5 days then. And if you haven't filed your plea by then, so you haven't told the court your side of the story as the defendant, you are then barred from doing so. That means after that, there's no turning back. Unfortunately, what we are seeing is, say, 2 months later, somebody finally wakes up and they're like, okay, cool, now I do actually want to file my plea. They just tell a sad story to court and say, I didn't have money for an attorney or whatever the case might be. And the court might actually still listen to you. Luckily, in this particular case, I think by this time, because the tenants already vacated the property, they decided, you know what, let's just let it go. And then look what happened. My actual goodness. Indeed, the court granted our order exactly as we prayed. Now, I know showing you this court order might not actually look like a court order, but this is what default judgment in the magistrate court looks like. I kid you not, this is the file cover, a photo of the file cover. And this is how we record our orders in the magistrate court. So in this particular case, our messenger obviously just went to court, drew the court file, and saw this and actually took a photo. And this is the judgment, and we execute in terms of an order like this. But look at the order. The first thing I actually want to point out is look at the file cover. It says there's a clear note, lease agreement, then, so the nature of a claim is based on a lease agreement. Again, showing you the importance of your lease agreement and the content of your lease agreement. Then, natural person. So the magistrate already makes notes. What kind of, I suppose this is more the clerk of the court, but what kind of a case is this? And what kind of person are we talking about? And in this case, we actually had two defendants, two natural people. The notes here is court queries. So if the court's not satisfied, because remember on a default judgment, you don't actually appear in court in the magistrate's court. So you just file an application, the court goes through, the magistrate goes through your summons, and then decides if they're going to grant the order or not. If they have questions like, what on earth is this claim you are on about? They write a letter to you. Actually, they just file it in the file, and you must hope your messenger gets the file and see the question. In this particular case, the magistrate actually had two questions. The one was around the early cancellation penalty. And the magistrate said, huh, what? And Khomotso simply replied to the court and said, yes, look there, clause 21, read with item 1.9, the parties agreed to this, and the court was satisfied. The next question, the next time around was irrelevant to for the purposes of this training, but I'll tell you, the reason for the next query was we had a part C, a claim C, where we claimed damages in case the tenant didn't vacate on the 31st of October, because remember we already issued on the 15th of October, so we didn't know if they're going to vacate or not, and the court wanted to know if we do want to move for an order in terms of our claim C, the damages claim, and we just said no thank you, they are already out. And the court ordered payment of the sum of 64,785 rand and 28 cents, that is the arrear rental, as well as 40,000 rand against the first and second defendant jointly and severally liable, and we also got costs. So it's very important to know this, and I'm very happy that I had a case all the way from SSLR that I could share with you, because we very often feel like our lease agreements are, you know, just there, but does it actually have an impact? Does it actually change things? And especially if you've been in the tribunal on one or two occasions with specifically early cancellation penalties, and you've been unsuccessful, you might feel like, oh, you know what, it's not even worth completing it in the lease agreement. But if you go to an actual court, this is the way courts apply the law, and you are entitled to your early cancellation penalty. And it's very important to know that if you follow the correct process, you will definitely be successful on behalf of the landlord or the landlord himself. So let's quickly discuss a few potential issues and questions that I've had. What do you do when the tenant sends you the early cancellation notice? Please don't just accept it. Tell the tenant, listen, Mr. Tenant, just go look at your item 129. Go read clause 21. Know that this is enforceable law. Very often, especially now, tenants are cancelling agreements because they think they're going to be better off. They think it's going to cost them less. In this particular case, how sad is this? They were already in arrears by August. Then they sort of started paying a bit. They almost got better. Then by October, they thought, you know what, this guy's not going to fly. We need to cancel. But still, it ended up costing them over 100,000 rand because they still have to repay the arrears. And they now have the 40,000 rand early cancellation penalty. So please communicate with the tenant. As the agent, you're acting on behalf of the landlord. I know that. But it's very important to know that it's also your obligation to try and just tell the tenant exactly what's going to happen. If you do an email and you say, hi, Mr. Tenant, I'm so sorry, it's going to end up costing you X amount in terms of your lease agreement. Are you sure you want to persist with the cancellation? And the tenant says, yes. You've just made my case on behalf of the landlord much, much easier. because we can even demonstrate to court in terms of the principles of Ubuntu. We have tried to help this tenant. We knew he's cancelling because he's financially strained. We tried to say, listen, Mr. Tenant, this is not the way out. You're probably better off sticking it out, because now you don't have to pay the damages and rent on a new place, at a new place. You've tried to help him. So don't just accept it. Also remember, you can invoice your early cancellation penalty the moment you receive your cancellation notice, but the payment is only due on cancellation. So let's take our case study as an example. On the 1st of October, when they receive the notice to vacate, it's a smaller nod for the things people call things. When the landlord received the notice of cancellation, which would have only been effective then on the 31st of October, the landlord could have invoiced the 40,000 Rand on that day or the day after that, but only with the payment due date being the 31st of October. In that case, it means you hold the deposit until the damages is paid. Obviously, you can set off your early cancellation penalty from your deposit. Please never pay the deposit out, hoping that the tenant is going to pay the early cancellation penalty. That's not going to happen. We've had a few cases where landlords did hold on to the deposit in lieu of the early cancellation penalty. The tenants have gone to the tribunal to claim it. In some cases, they were successful. In some, they were not. Otherwise, same thing in the tribunal. Landlords claiming early cancellation penalty through the tribunal. Some were successful, some were not. And it's not just limited to, I know the Western Cape Tribunal doesn't enjoy early cancellation penalties as much as Joburg, but it's not just that. It's not just in this tribunal this will work, in this tribunal it wouldn't. And remember, there's no difference in this from one area to another. This is legislation, so it's applicable across the board on all tribunals. Never let an order from a tribunal make you think you can or can't include or exclude something from a lease agreement, or claim something or not claim something. Unfortunately, the tribunal, or fortunately, the tribunal doesn't make law at all. We don't even have a precedent system running through the tribunal. So unfortunately, it's putting people off from claiming an early cancellation penalty. But as we saw in our case study, it's something that's enforceable. If you then invoice the moment you receive the early cancellation notice, and let's say they vacate then on the 31st of October, so the full 40,000 Rand only becomes payable on the 31st of October, and you can place a tenant from the 1st of November. And then you need to refund the full 40,000 Rand. However, if you can only place a tenant on the 1st of December, obviously you're going to refund the tenant with 20,000 Rand. And honestly, after that, after the time period that the tenant paid for, the time period of the early cancellation penalty, if you can only place a tenant at that point, that would mean that the tenant's not going to be refunded in any way and is not entitled to it. But something very important to keep in mind, if your lease agreement says maximum penalty 2 months, in our case, 40,000 Rand, that 40,000 Rand then includes everything. Now the landlord can't claim on top of that, but my prorated commission, or on top of that, you know, I could only place a tenant another month later, so you still owe me another 20,000 on top of the 40,000. It's very important to keep this in mind. You can't add things to that. But what is important is rent is due up to the point of cancellation. So your 40,000 Rand claim isn't for the month of October as well. The tenant was still in occupation up to the point of cancellation. So in our case, the 31st of October, rent is still due. So you can't say, but you've given me 3 months cancellation notice, so you were paying your penalties while you were still in occupation. That's not the case. You are paying rent up to the point of cancellation. Cancellation penalty kicks in on cancellation, and you can then only claim the reasonable cancellation penalties up to that point, and anything more than that, unfortunately, you are limited to the amount that the parties agree to in terms of the lease agreement. I hope this makes sense, guys. I do hope we've covered everything and that you do understand application of this on a really practical level, and that you will not end up with loads of early cancellation penalties, and that if it does happen, that it is a smooth and relatively easy process to go through. I really hope that you're going to enjoy the rest of July, that things will be a bit more calm and less chaotic in our country. And really, I hope that you are all safe from everything that's happening right now. And please stay safe and stay warm. It is absolutely freezing cold, but have a lovely day and enjoy the rest of July.